that I think might illuminate our understanding of the law of war and the role of the Supreme Court in developing it. There's a case that I was personally involved in. It's a story of Bin Laden's driver named Hamdan, Saeed Ahmad Hamdan. I was sitting in my office in, I think it was the summer of 2004 in Jerusalem, minding my own business, not paying any attention really to any practical problems. I never have paid much attention to practical problems. I was working on some academic subject, and suddenly I got a telephone call. This is Major Dan Morey. Who was Major Dan Morey? I've never heard of Major Dan Morey. He's apparently a big shot in the JAG. And said, look, we need somebody to argue against the use of military commissions against this driver, Hamdan. But you're the JAG. Why are you interested in this? I mean, aren't you in favor of the president's policy? Well, no. The basic argument is the military commissions, one of which was they're going to use against Hamdan, are an insult to military justice. This is a really important point, that military lawyers have taken the position, and I think properly so, that they should have pride in the Uniform Code of Military Justice. This has taken decades to develop. The basic rights of criminal defendants are recognized, but outside of this sphere of the Uniform Code of Military Justice, President Bush developed an institution called the Military Commission. There's a history behind it. It was, whether it goes back to Washington or General Scott in 1847, that's what was the debate. It's been used a few times in history. Roosevelt invoked military commissions against the 8 saboteurs who landed in the United States. And then Bush decided November 13, 2001, that he was going to recreate the military commission and use them against alleged terrorists. Now, they didn't really have anybody to try at the time. There were all these people in Guantanamo, but it took them a long time to decide on any particular defendant. Finally, they decided to focus on several defendants, including my client, Hamdan. So the JAG requested of me a brief on the question whether the charges levied against Hamdan could hold up under the law of war. Now here's the important point. A military commission is outside the regular system of criminal justice. It is not recognized under Article 3, which recognizes the jurisdictional federal courts. Being outside the system of justice, of course it doesn't follow the rules of the Constitution. You don't have a right to a jury trial. You don't have the basic rights that are recognized under the Bill of Rights. So the justification has to be someplace else under the law of war. Now there are various ways to challenge a military commission. And in the Hamdan case, there were basically two strategies. In the actual trial of Hamdan, he was asked to leave the room when one of the witnesses testified against him. Now, that is a no-no. You cannot do this in a federal criminal trial. You cannot protect your witnesses by concealing their identity, by having the defendant leave the room. This is a violation of what's called confrontation of witnesses under the Sixth Amendment. That part, I think, was fairly easy. And to tell you the truth, I think that the defense of Hamdan could have really rested on that particular point. But the JAG wanted to go further. And they wanted to test the general theory of what is the law of war. And in order to test that theory, I developed the argument that they could not use conspiracy charges under the law of war. Now, the interesting thing about 2011 and the attacks that are related to it is that it is primarily a conspiracy that people are guilty of. We don't have a crime, as most Europeans do, called membership in a terrorist organization. If we had such a crime, it would be very easy to prosecute the members of Al-Qaeda for being members in a terrorist organization. We do not have a crime of that sort, and we have not had one since that idea was discredited in the Communist Party cases in the 1950s. Membership is not a crime in the American view. You've got to actively support the unlawful cause. Merely being a member of Al-Qaeda cannot be a crime. Now the question is whether a conspiracy, joining a conspiracy to commit the events of 9/11 could be charged as a crime. And there's no doubt in my mind that Hamdan was actually guilty of this charge. He was bin Laden's driver. He was happy to be bin Laden's driver. He may have been earning a living on the side, and he might have said, I was just doing it to earn a living, but he was a true believer in the cause of Al-Qaeda. And he provided some kind of assistance by driving the car. To defend him, and I thought it was a wonderful challenge to defend him. It was something that my relatives in Israel never understood. They said, how could you be defending, this terrorist? How can you do that? Well, that's part of what it is to be an American lawyer, I think, is to see the virtue of the defense as a cause in and of itself, to test the legitimacy of the government's prosecution, whether you think the guy's a bad guy or not. That makes no difference to me. So one argument that could have been used is that the procedures in the tribunal violated the Sixth Amendment because they forced Hamdan to leave the room. I think that's an easy argument. The more interesting challenge, and the more basic challenge to the law of war, is whether it includes the charge of conspiracy. I developed the argument that it did not. And in doing this, I learned something very important that actually moves me deeply. Because most of my life I've been a theoretical lawyer. I've written books. I've taught wonderful students like William Merkel. But I'm not really a man of practical affairs. And it surprised me greatly to learn that a theoretical argument can win the day. That the courts really do understand. You can go to court and make a deeply theoretical argument based upon international law, based upon comparative law, based upon history of law. You can make these arguments and they will understand. And the amazing thing is that in the final analysis, the Stevens opinion in the Hamdan case basically took over my brief and repeated the fundamental arguments that conspiracy is not part of the law of war. Why did he have to do that? Because actually there were already 5 votes on the issue of procedure. Kennedy voted in the separate opinion. Stevens and the 3 other liberals voted together on the issue of substance. They added the substantive issue because it was important to make the point that the law of war, which authorizes this unusual procedure, is not unlimited. It cannot simply be defined the way the president would want to.